presentations and then be questioned by the board. After all opponents have spoken, each side will be given an opportunity for a brief rebuttal. This meeting is being tape recorded, and it is very difficult to hear what is being said when multiple people speak at the same time. So please refrain from interrupting other speakers. Questions should be addressed through the chair. We ask that each person offering testimony come forward to the microphone and begin by giving his or her name and address. In each instance, the burden is upon the applicant to demonstrate compliance with the provisions of the applicable ordinance and ordinances. Applicants for variances must specifically address and prove compliance with each of the 4 undue hardship criteria. Following a decision on any application or appeal toward the end of the meeting, the board will prepare a written decision indicating its findings of fact and conclusions of law that will be mailed to the applicant within 7 days of the board's vote. The applicant is free to stay during this written decision process, but is not required to do so. If your appeal is granted, you must obtain a building permit from the CEO. If anyone wishes to appeal the board's decision, you must do so to Superior Court within 45 days. Are there any questions about what I've just read? Seeing none, we will jump to the board business. Since we haven't met in some time, we're required to nominate and vote for officers. We have chairman. What's that? Oh, you want to do the roll call first? Yes, I agree with you. Can we have a roll call? Starting at the left. So I've got, do you have everybody's? I've got it right here. Gary Barker. Here. Courtney Barnett.
Present.
Mark Curtis here. Dan Nichols.
Here.
Craig Sterling.
Yes.
Michael Wiseman. And then my list is wrong.
I'll hold in check.
Thank you. I have an old list. All right, so we got that. Now we can jump to election of, we have a chair, vice chair, and secretary. Entertaining motions?
I nominate you, Mark Curtis, to be the chair.
Figured that might happen. Thank you.
I would second that motion.
Thank you.
Second.
Dan. Thank you. Any discussion? All in favor? 6? I'm not going to vote for myself. We need nominations for vice chair.
Courtney? I nominate Courtney.
Okay, we have a nomination for Courtney. I'll second that one. Any discussion? Seeing none, all in favor? 6. Now we need a secretary. Nomination for secretary. I'll nominate Dan. Any second? Second. There we go, Court second. Any discussion? All in favor? 6. Thank you. Thank you. All right, so without further ado, we will move on to tonight's reason for meeting. We have an appeal, 24-01, variance from zoning space standards. Brian Garrity, property owner and petitioner for Middle Jam Road LLC, is seeking a single-family dwelling setback variance for map 97, lot 37.002, zoned suburban residential. This time, we'd ask the applicant to come forward and make their presentation.
Is the paperwork
right to the mic.
Is the paperwork all in order? I received an email earlier, about 2 hours ago.
So before we get to, first, who are you? What's your address? And then we'll jump right into that.
Sorry, I'm Brian Garrity. My address, my home address,
Whatever address.
50 Wagner Farm Road in Gorham.
Yep.
And then you want me to just go into?
Well, if you had a question to start with, we're happy to.
Oh, I'm
try to
sorry.
address
So
that.
I got an email a couple hours ago
Yeah.
stating that I had filled this out wrong or the criteria was not correct.
Who did you receive that email from?
Scott sent me an email.
Want to address that?
Yep, I sent him an email on, by words that we should inform him so he's not blindsided when he comes in here, that he's notified that there was a issue with the way the application was filled out.
All right. Do we need to, it sounds like a good question for the town attorney. Mark, would you like to weigh in on any of that? Is there anything that we need to be concerned with, or can we just adjust the notice issue? Or
Yeah,
that?
I'm happy to address it. I think that the issue that was raised, and I pointed out to Scott, was that the statute and the ordinance on a setback variance for single-family dwelling says that it's strictly limited to permitting a variance from a setback requirement for a single-family dwelling that is the primary year-round residence of the petitioner. And in reviewing the application in advance of the meeting, it appeared to me that that was not the case for this one. Not to say that he couldn't amend the application to seek a different kind of variance, but in my view, that would need to be renoticed, or sort of renoticed with new notices going to abutters, because what was noticed thus far was not was a single family, a setback variance for single family dwelling. And if it's going to be changed, then I think that needs to be renoticed for that. So I guess one option would be to, if the applicant would like to continue the meeting to allow for an amendment to the application, so he doesn't have to fill out a new one and do a new filing fee, to just simply to amend it. But then new notices would need to go out.
So it would postpone the proceeding in the sense that we would have to send a notice and then wait that timeline and then reconvene?
Probably, in next month's meeting, or we could have it. So I think.
And what, in your opinion, what criteria or what appeal proceeding should we be, or what application should he have used? Or
Yeah, so to the extent that it's not his primary year-round residence, which it sounds like it's not based on the address that he stated at the outset, the other option for variance under Gorham's ordinance is a hardship variance. Because of the only, other than that, I believe the only other variance that is allowed under Gorham's ordinance is a disability variance. So I think it would be, the only other option, the default would be a hardship variance. But I think it could be amended from what it was before. Obviously, that's a different standard than the setback variance. And so a different the application would need to be amended to reflect that different standard. And also to allow for a notice to abutters to be redone with the different, because currently what's being requested is a single family setback variance. If it's changed to a hardship variance, then that should be what is noticed.
Right. Thank you. Just a quick question, Scott. What is the current status of the building itself? Is it built and it's an existing home, or is it?
No, currently right now, the full foundation is in, and it is seal coated, but there has not been any backfill, just slightly up front, but nothing around the whole foundation yet. At the time I went out there and issued a verbal stop work order.
Okay. Mr. Garrity, seems like we have a little bit of an issue, but let me ask one quick question.
Sure.
You live in Gorham now,
Yes.
correct? And I guess maybe I want to kind of run this by the attorney first, but you can't live in a foundation, Mr. Bauer, correct? I mean, it's not a finished dwelling. So I have no idea, and I'm not going to ask the question quite yet, but if he had the intent to live in the home, is there anything that we would need to change about the application?
All I can tell you is what the statute says, and the statute has to follow, the ordinance has to follow the statute, and the statute simply says that a municipality can adopt an ordinance that permits granting of a setback variance for a single-family dwelling. The ordinance adopted under that section may permit a variance from a setback requirement only when strict application of the zoning ordinance would cause an undue hardship, and then it defines undue hardship. And then it says that the ordinance adopted is strictly limited to permitting a variance from a setback requirement for a single-family dwelling that is the primary year-round residence of the petitioner. So you could interpret that to mean that it's for an existing residence that may need a setback variance for a deck, other structure, that type of thing. Mm-hmm. But I think, the key part of it is whether this is the primary year-round residence of the petitioner currently.
Interesting. I was not expecting that question to come up. I guess does any of the board have any question about that? Because it seems to me that the attorney is advising that this should be renoticed, I'd ask the applicant, but before I do that, I want to give everybody else the opportunity to ask either the attorney a question or the applicant a question through the chair.
So my understanding is that what Mr. Bauer is saying is that the application as it's currently submitted is legally required to fail. And so what we're essentially talking about doing is giving Mr. Garrity a chance, in fairness to him, to amend his application to something that at least has a chance of succeeding.
Right, and the problem there is if he amends the application, it requires a new notice, which requires a reset of the timeline and another meet, which I'm happy to meet. That's not my problem, but knowing construction as I do, usually there's a timeline on that, so I'm trying to be sensitive to that at the same time.
Yeah, and it's more also to protect the board's process. You know, I don't want to advise the board to do anything that would open up a potential, you know, issue on if there were an appeal, that kind of thing, that somebody was not properly notified of what was being requested. You know, and so that's the reasoning for saying that if there is an amendment to the motion or amendment to the application, that it be renoticed with actually what is being requested and not what is currently on the agenda for tonight.
Any other questions for the attorney or for the applicant?
So I'm still unclear here.
Okay.
This is a building permit for a single-family dwelling, and so where does it say that that has to be is going to be your permanent year-round dwelling? I guess when I'm confused, like,
Is that
we're living one place in Gorham and we want to build a new home for ourselves elsewhere in Gorham. We're going to live in the home we live in until the new home is built, then presumably sell that. I'm not clear.
I agree with you that it seems like maybe the law and the ordinance that we're speaking of right now maybe didn't consider this particular situation, that there would be, I think, as you said, it may seem like the way is it law? Is that
The statute. Yeah.
Statute, okay. So the statute considered, as you said, as the town attorney said, if you were going to add a deck or had added a deck to your personal dwelling that you were already living in, I don't think it necessarily considered that if somebody put a foundation in the ground, because it's not currently a dwelling, in your opinion, Mr. Bauer, that would fall under a different criteria, and he would have had to make application under that criteria, correct?
Right. I think if it's not the current primary residence, then it would be a hardship variance.
Okay. In an attempt to make yeah.
And we can't ascertain if can we deal with intent?
I think we can ask the question. I don't know if it technically changes anything, but I think it would be worth asking the question. Mr. Garrity?
Yes.
The question seems to be from the board. Do you intend this to be your year-round residence eventually?
No.
Okay. So I think and we appreciate the honest answer.
Yeah, of course.
Yeah.
So, question for Scott, I guess. Is there a different appeals application for a hardship variance?
I think, well, we don't have, it doesn't, on our current application, it doesn't say, I mean, this is one where I kind of asked Mr. Bauer, the variances that we do have is variance from a zoning space standard or an administrative appeal. So I don't know if this is a different, you have to forgive me for not knowing, but if there's a different application for the hardship one that he should be filling out?
So for your ordinance, it's section 1-4B2, variance appeals. It allows for a variance to be granted only where the strict application of the ordinance or provision thereof to the petitioner and his property would cause undue hardship. and then it defines the words undue hardship with the four-factor criteria. This is section 1-4B2. So then B3 is the single-family dwelling setback variance appeal, which is what was requested. But in that section, it says that this subsection B3 applies only to variances from setback requirements for a single-family dwelling that is the petitioner's primary year-round residence. And so that's what I had flagged. Subsection 1 is administrative appeals, as you pointed out, Scott. So the three things under the ordinance, at least, are administrative appeals, variance appeals, which I would call a hardship variance, and then a single-family dwelling setback variance appeal. Those are the three things that this board can hear under the code.
To clarify, there was public notice made, both website, published newspaper or something like that. I assume, Nina, you placed that? What did that notice look like and what did it say? Because if that notice wouldn't have been any different, if it just said, Mr. Garrity is appealing, has an appeal. Right, so if the simple notice that went out wouldn't have been worded any different.
I don't know what the wording was, but
Right, that's what I'm asking.
or what the wording of the abutter notices, but I think regardless of that fact, the application is part of what the packet that's posted as part of the agenda, and so if someone was looking at that and thinking that this was just a simple setback variance for a single-family dwelling as opposed to a hardship variance, they may or may not have had an issue with that. I guess that's.
I'm not arguing
That's
against
fine.
you. I'm just
Yeah.
trying to understand because in the end, though, no matter what, whether you consider it a hardship or a setback, it is essentially a setback. It's a hardship because of the setback, or it's a setback. And again, I'm not saying that we should take it up tonight. I'm just saying that in the end, that's really what we're going to consider is whether or not the encroachment into the setback is either a hardship and considered under the hardship rules, or it's a single-family setback appeal, which has specific criteria on that.
Correct.
Okay.
So, which are two different and varying levels of difficulty to meet. Yeah, I guess I would put it that way.
Do you say, based on my experience, the hardship is harder to meet than the single-family setback?
Yes.
Okay.
I just want to also note that this application that Mr. Garrity signed when he checked single-family dwelling setback variance, if you look at it, it's pretty clear that the requirement is that it has to be the petitioner's primary year-round residence, right next to where he checked. So I would propose that we proceed on the application as filed, because the application, that was what was noticed. That's why we're here. That's why Mr. Garrity's here. And so that would be my recommendation.
I don't have a problem with that recommendation. I think, is it appropriate for somebody to make a motion and then the whole board votes on that, Mr. Bauer?
I think the only motion that you would need would be if you wanted to continue the meeting to allow, if there's a request to make an amendment to the application, there would need to be a motion to continue the meeting by someone on the board. If there's not a desire to continue the meeting, then you can just proceed with the application as it stands. So
When you say not a desire to continue the meeting, you mean not to stop and then continue at a later date?
When I say continue, I mean
Continue right now.
Table.
Yes, table.
Table the application, continue whatever you want to call it. Yeah, table it to a different meeting. So I think that's the only motion that you would need is if you wanted to table it to a future meeting.
And if we don't want to table it, we just start right in?
Proceed with the application as it was submitted, and you can go that route as well. It's up to the board to decide.
We have one opinion. Are there other opinions? Or I guess I would look at it this way, is since we're not going to take a vote necessarily for that, I would say if there's a differing opinion, I'm willing to hear it now.
Well, we have to don't we have to decide which direction we're gonna listen, if you follow me?
Yes, in some way, but I think I think it would be easiest if somebody said, you know, I make a motion that we continue on, or I make a motion that we stop, and then we had a vote, but it doesn't sound like that's really the correct procedure, or could that, I mean, we could do that anyway, couldn't we? I mean,
Sure. I mean, you could have a motion to continue in a second and then have a discussion as to whether you want to continue it or hear it tonight, and then have a vote on the motion to continue. That might be the easiest way to proceed.
Okay.
I'll move to continue.
When you say continue, and because I think you're
Yes,
right.
I will move to continue the hearing this evening on
Right.
the application.
Right.
To table to a future meeting.
No, I don't
Okay.
think that's what he's
So,
saying.
so when I say continue, and
Right.
continue has a specific connotation. Continue means to continue it to a different meeting. So I'll say table. So a
to
motion.
proceed.
Motion to proceed.
Okay,
on
so
the
you don't need to
application.
do a motion to proceed because you already sort of are in the,
Okay,
on the
so then-
agenda item. So, sorry.
So let's make the motion the other way then. Motion that we continue which means to table it, and then we can have a discussion and vote. If it fails, then then we proceed with the meeting tonight.
Yeah.
I'll move to continue.
Okay. Thank you. We have a motion.
Motion to continue it to the October meeting, I guess would be the, yeah, okay.
We have Dan Nichols seconding. Now this is where we can have some discussion. I mean, I'd be happy to hear from each board member as we roll down the table. Mr. Wiseman, you have an opinion or a thought or anything to add before we have a vote?
No.
Gary?
Well, like I said, I need somebody to tell me which line of thought we're following.
I think this is one of those things that the attorney has given very clear advice. I would venture to guess that Powell has a different opinion and wants to grant the applicant the hearing tonight. I guarantee if we ask the attorney, he's going to tell you that he's right. I'm not saying he's wrong. But I think this is one of those things that we have to make a decision whether or not we continue on or we, if you don't mind, I guess I'll ask the question. How significant is the loss of time to wait
Till October?
yes.
Is there not a meeting in September? Can I ask that?
What's the quickest we could put a meeting together? If we had to, I mean, tomorrow's Friday, the town doesn't work.
Yep.
Monday's a holiday, so the earliest that anybody would act on getting new notice out would be Tuesday, assuming that there isn't an avalanche of other things they're supposed to be doing. So,
Right.
Nina, would you?
I don't think this is a proper line of questioning.
No?
I think if we're going to continue, in effect, table it, we need to act on that. I don't think we can try to make a promise about when we might meet to be a convenience to the applicant.
Fair enough?
And I may have misspoken. I am already thinking that we're in September because kids are going back to school and everything. So it may be that, it would be
Okay.
a September meeting. I apologize. I'm skipping ahead to October already in my head.
For clarification, without a promise, it would be the next meeting that is available.
Okay,
It wouldn't-
thank you.
They wouldn't miss, so I guess I'll rephrase my question. Knowing that, I mean, we're not going to leap over tall buildings to get you a quicker meeting than anybody else, but there's a standard meeting procedure and we would get there. I mean,
That would be fine.
okay, so
Yes.
does that help with your contemplation? Court?
Yeah, my only concern is kind of the notice that went out, and it was improper. So essentially, I think we should table and allow to amend, but
No,
that was my thought there.
Perfect. Howell?
I've got nothing to add.
Okay. Dan?
Part of me is saying, I think we should continue on with the meeting because everyone's here.
Sure.
I don't know that we're going to get any new information based upon what the applicant has given us already. But the other part of me is saying it was filled out incorrectly and that we probably should table it to another meeting. So I think I'll go with the latter.
I understand. Mr. Sterling?
Yeah, I agree. I think we need to table it. This he clarified that the only appeals are the 3 on the sheet, which is what I was asking Scott about, and it's an incorrect application. I think we're on thin ice if we try to smooth this over. So, yeah.
Any other discussion before we have a vote? As a reminder, the motion in front of us is to table the application that's in front of us, allow it to be amended, and then have it noticed, or a new notice sent out, which is corrected.
Is,
I kind of
is,
summarized that.
is an amended application require a whole new fee?
I don't believe so. No. All in favor of the motion? Fairly unanimous right there. Not very often. Sorry to call everybody out. We'll give you the opportunity to amend the application, and then obviously in the pace of the town, we'll have you back here and contemplate it correctly.
I appreciate it. Thank you.
Thank you.
Thank you.
And I think that concludes our business, unless I'm unaware. Anything else we're supposed to be doing?
I believe that's it.
Okay.
We just need a motion.
Motion to adjourn?
So moved?
Dan moved to adjourn, seconded by Gary. All in favor? Unanimous? Everybody wants to go? Thank you.